Our next speaker for this afternoon is Matthew Moriarty. He is a partner with Koprince Law, LLC, where he's an exclusive practice of federal government contracting law. Matt works with clients on litigation matters in various forums, including Government Accountability Offices, GAO, U.S. Small Business Administration, and the U.S. Court of Federal Claims, and among others. He also assists clients with transactional issues from various business to business relationships to compliance with various socioeconomic statutes and regulations. Matt is well versed in the entire federal contracting regulatory landscape. Matt enjoys working with small businesses to help them solve their problems. You can follow Matt on Twitter. Moriarty GovCon, or his email, mmoriarty@koprince.com. Take it away, Matt.
Thank you. Thank you for the introduction. Hello, everybody. I'm coming to you from my living room in Kansas City, Missouri. I apologize. As you can see, I still have my COVID beard, still have my COVID haircut. I'm hoping to have that remedied soon. But what I'll do now is start sharing my screen so you can look at the presentation instead of this face. Okay, I hope everybody can see that. If you can't, please let me know. So, you know, I've given this a presentation like this a couple of years in a row now, and when I started, you know, I would say, "Wow, what an unbelievable year! I can't believe how many changes." And now, you know, it's just again, you know, can you believe nobody saw 2019 coming? Nobody saw the early parts of 2020 coming with COVID significantly affecting this this meeting even. So we're living in a world where things are going to keep changing, but you know, we're here to sort of help you sort it out, we hope. Move on. Okay. So today what we will be talking about is what we've seen over the last, I'm going to say 15 months or so, maybe even a little bit longer, and what we will expect coming soon. And those changes coming soon are, frankly, basically already here. Before I get started, I did want to plug our blog. It is at smallgovcon.com. I think a lot of the people in this meeting probably are aware of the blog run by the Koprince law firm, where we have over 500 blog posts about federal government contracting issues. So let's say over the past year, give or take, quite a few months, we've seen tremendous challenges. Like I said, tremendous changes that used to be something that we thought was unusual, but the fact is it's going to keep happening. So let's just get going. First and foremost, big changes to how businesses calculate their size. Just a little bit of a background. I'm sure everybody knows this, but a company is a small business if its size falls under the standard for the corresponding NAICS code. So, of course, when you get a solicitation issued, the first thing you do is go find the NAICS code, North American Industry Classification Code, to figure out what size applies to that contract. for socioeconomic program eligibility, that would be the 8A program, the WOSB program. You have to determine your size based on your primary NAICS code. We talked about eligibility per contract, and size includes your company plus any affiliates. Affiliation is a big issue in federal government contracting. We're not going to cover it a lot in this presentation, but I'm sure you'll hear about it over the course of these 2 days. Determining size matters what type of contract you're going to be seeking or performing. For service contracts, general services, construction, and specialty trade, you're going to be under a revenue-based size standard. So that means your size will be measured based on your annual receipts for the last 5 completed years. Annual receipts equals total income plus cost of goods sold. And where the rubber meets the road with regard to these size determinations is your tax returns. However, the SBA may look at other information. For example, let's say you haven't filed your taxes yet for 2019. Let's say, for example, something crazy like COVID happens and a lot of people put off filing their taxes. So if that happens and the SBA needs to determine your size for 2019, they'll take a revenue statement of some type. Now, if you're not doing a service contract, so if you're manufacturing or you're supplying products, you're going to be measured under an employee-based size standard. And that's the average number of employees over the preceding 12 months, including all employees, full-time and part-time, including those that you have obtained from a temp agency. So temp employees are included. However, volunteers are not. Sometimes there's a lot of debate over whether an independent contractor is an employee. The SBA has some guidance online where you can look to that. It pretty much matches the IRS guidance of when an independent contractor is an employee or not. The big change, of course, and everybody's aware of this now, probably, was the Runway Extension Act. This act was passed by Congress in late 2018. It came as something of a surprise, I believe, to the SBA. I don't think that Congress kept SBA in the loop on this as much as it could have. But what the act did is it required the SBA to calculate receipts over a period of 5 years as opposed to the 3-year historical period of calculation. The SBA pushed back, I think it's fair to say, pretty significantly regarding putting this act into effect. The Extension Act passed in late 2018, and the SBA almost immediately indicated that the act will not be effective in its opinion until the SBA updates its regulations. We wrote about this, and this is all water under the bridge now, but in our opinion, that was simply incorrect. When a statute passes without an effective date attached to it, it becomes effective immediately. However, in February of 2019, the SBA claimed the act didn't apply to it. However, in August of 2019, the SBA updated its regulation to say that, oh, I skipped a part. SBA OHA upheld this opinion and said that the 3-year standard applies. And that the Runway Extension Act will apply as soon as SBA promulgates new standards, which is exactly what happened early in 2020. The SBA said that the 5-year measurement period is effective. It quite cleverly, in our opinion, included a 2-year transition period, meaning that until January 6, 2022, if you're the subject of a size protest or otherwise having your size determined, you may, as a contractor, elect to have your size measured over either a 3-year or 5-year period. The Form 355 that people are familiar with having to fill out and submit when size is at issue has been updated so that you can elect what standard will apply to your size determination. One interesting thing that I don't believe we know the answer to yet is, does that selection last for the entire 2-year period? I.e., let's say you're protested and you say, I'd like to have my size measured over a 3-year period, not a 5-year period, and then you were found small, then something changes 6 months later or 12 months later, and there's another protest. At that time, can you elect to be measured over a 5-year period? I don't think we know the answer to that. So some of you may be wondering, okay, so why is a 5-year standard or a 3-year standard such a big deal? Let's assume that you're a business that is experiencing linear growth. Okay, that means growth over time, becoming larger and larger each subsequent year. So that business is, let's say, bidding a contract that is for architectural services under an 8 million size standard. If you look, based on this slide, over a 3-year average, the business would be a large business ineligible to bid on the project. However, over a 5-year average, the business would be small, eligible under the 5-year standard. But why wouldn't everyone elect to use a 5-year standard then? Let's take a look at a different type of business. This is a business that had much more success years ago and now was hoping that those years would come off its books so that it can transition back to a small business. Let's say, you were waiting for the end of the fiscal year of 2019. You were hoping to begin bidding on small business contracts. Suddenly, Congress passes this rule change and says, nope, sorry, it's 5-year standard. That puts that 20 million 2015 and that 10 million 2016 back on your books. So if you didn't have the option to elect to be measured over that 3-year average, the historical 3-year average, then you would be an ineligible large business. So it's a very good thing that the SBA chose to do, adding in the option to pick either a 3 or 5-year standard. Oh, I see there's a question about access to the slides. This is being recorded, so my understanding is that these slides will be made available, yes. So speaking of size standards, recently in late 2019, the size standards did increase to account for inflation. You may want to take a look at your SAM profile to see what representations and certifications you've made, and double check, frankly, to see if had you been a large business under a certain calculation and you were quite close to the border, since those standards have been increased, you may very well be a small business again. Take, for example, and I'm not going to go through all these, but you can see some size standards. They all kind of increased a couple of percentage points, sort of across the board. Nothing increased so dramatically that it would make a huge difference. However, you know, I mean, an extra $1.5 million here and there, it would make a big difference to me. I don't know about you. So that was revenue based, right? But what about employee based size standards? There is an act called the Capturing All Small Business Act that would change the employee calculation period from 12 months to 24 months, kind of like the way the Runway Extension Act extended the time period from 3 years to 5 years. This act has not passed yet. It passed the House. I don't believe it has passed the Senate as of this this recording, and it may well die after passing the House. But it also may have the same issues as the Runway Extension Act, because again, it's not clear if the SBA was sort of brought into the discussion before changing this. So let's move on. A lot to talk about. There were significant changes to the Hub Zone program over the last 12 to 15 months. Let's talk about the eligibility requirements, kind of as they were, what we call the ordinary eligibility requirements. To be a hub zone, you have to be a small business under your primary code, at least 51% owned and controlled by persons who are U.S. citizens, have your principal office located in a hub zone. Principal office is a little tricky, by the way, because that's not your headquarters for sure. It may be. But really, it's just where you have the most of your employees working. However, if that is a job site, that does not count. So let's say, for example, you have a headquarters where you have 12 people, you have a satellite office where you have 4 people, and you have 60 workers on a job site. Your headquarters, therefore, would be your principal office, because it is where you have most of your employees working. That is not a job site. Also, the sort of last prong of hub zone eligibility is that at least 35% of your employees reside in a hub zone. Not necessarily the hub zone that your principal office is located in, a hub zone, all right? And just FYI, the SBA will round up to determine how many employees have to be in a hub zone. So for example, if you have 95 employees and you're trying to, SBA is trying to determine how many of those 95 have to be residing in the hub zone, you multiply 95 times 35%, that equals 33.25 employees. Well, you can't have a quarter of a person. So SBA is going to round up to 34. Okay. Why were these changes that we're going to get to made? Well, the Hub Zone program has not been as successful as some of the other programs. The annual Hub Zone contracting goal is 3%. Annual achievement of that dollars to Hub Zone contractors is usually less than 2%. So the SBA changes, in our opinion, somewhat recognize that there have been some deficiencies in the program. So these changes include some changes in Hub Zone tracks, allowing employees to relocate. We'll talk about that a little bit more.
What?
And active compliance required as of, sorry?
Yeah.
Okay. Active compliance is required as a bid and award date. That was the previous rule. the rule change effective late 2019 should make compliance easier. So what does that rule change consist of? Well, your principal office, as we talked about, is going to be where you have the majority of your workers doing their everyday work. If a hub zone entity purchases a building or enters into a long-term 10 years or more lease in a hub zone, it will be determined to be in a hub zone for 10 years. As for employees residing in a hub zone, if the employee lives in the hub zone location for at least 180 days, then the employee will be grandfathered in as a hub zone employee. So what that means is if the employee lives in the hub zone at the time of certification, the employee will be seen as a hub zone resident for the entirety of his or her employment, even if he or she moves out of the hub zone. The reason for this change, by the way, is that so the hub zone program is intended to bring development to historically underutilized zones. And part of that development is jobs, right? So when a new business comes to a historically underutilized business zone and starts offering people jobs, their circumstances improve. And while they had been living in a hub zone, they may wish to upgrade to a better apartment or buy a home. If so, they should not be penalized for that. So this is a quite wise change to allow those employees freedom of movement to improve their situation. Now you do have to attempt to maintain compliance with your hub zone 35% requirement. Previous to this change, attempt to maintain was a bit of a standardless phrase. Now we know what attempt to maintain is. It means you have to have at least 20% while you're performing and while you're certified for the year to live in a hub zone. And if you go below that, then you have not attempted to maintain compliance. Key change again is annual certification of hub zone status. What that means is you no longer have to be hub zone compliant at the time of bid and the time of award. Now you get certified every year, and as long as you're certified, you're hub zone eligible through the year until your next recertification. So now there's no more of this, no more of this putting in a bid and being eligible and then waiting 6 months and the award comes and suddenly you're not eligible anymore. That's not going to happen. Another big change to one of the socioeconomic programs is doing away with WOSB, EDWOSB self-certification. The SBA will now certify WOSBs and EDWOSBs. So this change dates back years and years. In 2015, Congress eliminated self-certification by changing the statute to read that all WOSBs and EDWOSBs must be certified. That change took a very long time to implement. The SBA proposed its rule change to its regulations in 2019, halfway through 2019, and they have not gone into effect until you can see this summer. So as of July 2020, last month, the SBA has begun accepting applications to determine whether an entity can be a certified WOSB or EDWOSB. Great news, there is no fee associated with that. There has been a fee potentially in the past associated with third-party certifiers. That's not the case with the SBA. It will take some time for decisions to start coming out. The SBA has said that its first WOSB, EDWOSB determinations will be issued on October 15th. I suppose there's no reason why some couldn't be issued before that, but that's the timeline that has been put out. There will remain 2 options for certification. The first, of course, is certification through the SBA. That requires submitting documents to demonstrate eligibility. There should be a decision coming with that within 90 days. But frankly, with COVID-19 and with the fact that there are probably thousands upon thousands of firms who will be seeking this certification, there may be a bottleneck. We don't know, but we thought we'd point it out. Certification through the SBA can also be done by submitting evidence of verification through other programs. We'll talk about that a little bit more in the next slide. And the second option is, of course, third-party certification. I should point out, by the way, that certification through the SBA is through the Certify. I believe it's actually the beta.certify.sba.gov website. It should be up and running. I gave a presentation on the day that began accepting applications, and I do think there was a little bit of trouble just with the technology, but I expect that that's fully up and running now. Certification through the SBA. You don't need to make your case twice if you've already made it for a separate program, if that makes sense. So if you're a certified 8A participant, then you have already proven that you are a disadvantaged individual and you have enough control over the entity to be certified. So then as long as you're a woman, you're eligible. For the 8A program, because in order to be an 8A participant, you have to prove that you are socially disadvantaged and economically disadvantaged, then you can automatically be economically an EDWOSB, which is an economically disadvantaged woman-owned small business. Now that's not the case for SDVOSB or VOSB approval. However, if you are approved by the Department of Veteran Affairs, Center for Verification and Examination, I think it's, I always get the E wrong, but if you're verified by the VA's CVE, then you can show the SBA that you've been verified by them and you're a woman and you own the business, in which case they'll say, okay, you're a WOSB. The last of the other programs that will lead to WOSB certification is Disadvantaged Business Enterprise, authorized by the Department of Transportation. The Hub Zone program, unfortunately, cannot help. Certification through the Hub Zone program cannot help an entity become certified as a WOSB because, frankly, it's a different standard. Hub Zone program is about where the business is and who works there, not who owns the business and who controls it. So that's the key difference there. So SBA certification is going to be a formal process like the 8A Business Development Program certification. However, my expectation is it's going to be a little bit less convoluted, the way the 8A Business Development Program can be sort of a long drawn out process. Pardon me. To apply as 8A, you have to, again, prove you're socially disadvantaged in many cases and prove you're economically disadvantaged. For WOSB, you don't have to prove either of those. And for EDWOSB, you only have to prove that you're economically disadvantaged. This, of course, replaces the self-certification method that had been a part of the WOSB program for many, many years. What that meant is that self-certification was done on a contract-by-contract basis, meaning that by virtue of submitting a bid on a WOSB or EDWOSB project, you're certifying that you're eligible for that contract. The contracting officer was empowered to accept self-certifications, kind of just take the company at its word, unless the contracting officer had reason to believe that the company was not eligible. And of course, no fees. I mentioned that before, but it's worth reiterating. The SBA certification timeline is frankly pretty quick. One thing to know is that if an application is incomplete, it will be not evaluated. The SBA will let applicants know within 15 calendar days if an application is complete or not. If not, the applicant will be given the opportunity to complete the application. Once an application is complete, a final determination will be made within 90 days, quote, whenever practicable. We've come across the whenever practicable standard quite a bit. And it's a pretty good standard. The SBA will frankly go to great pains to hit that deadline. Consider that to be a hard deadline, but it is not, in fact, a hard deadline. So if there is a big bottleneck, like we discussed, that could lead to some longer timeframes. Pardon me. When you apply for WOSB or EDWOSB certification, you will get a determination in writing. You will either be approved and certified as WOSB, or you will be denied. If you are denied, you will be given a written decision that will lay out the specific reasons for denial. You cannot, unfortunately, appeal that decision to the SBA Office of Hearing and Appeals. However, you can request reconsideration of the decision within 30 days of denial, and you may provide additional information to explain to the SBA either why that decision is wrong, or perhaps why the reasoning for the decision has changed. What happens if you're a self-certified WOSB? Well, if you have a contract and you certified and were eligible as WOSB or EDWOSB at the time of the offer, then you are considered eligible WOSB or EDWOSB throughout the life of the contract. So let's say you're a WOSB, you self-certified, 2 years ago for a contract. You got the contract, and you're actually not that interested in certifying as WOSB now, but you do want to keep performing that contract. Well, you can. You're considered WOSB or EDWOSB through the life of the contract. However, if it's a long-term contract, i.e. more than 5 years, you will have to recertify as WOSB or EDWOSB, or have the agency no longer count awards to you toward their WOSB, EDWOSB contracting goal. What happens to third-party certifications? Well, they don't go away. You can still be certified through a third party. I have to be frank, I don't know why you would. They do have the option of charging a reasonable fee. They do use the same standards as the SBA. The SBA has approved 4 third-party entities to certify. businesses as WOSB, EDWOSB. They are WeBank, Women's Business Enterprise National Council, the U.S. Women's Chamber, NWBOC. I'm not even going to try with that one. National Women's Business Owners Corporation, and the El Paso Chamber of Commerce. Women's Chamber of Commerce. I had to omit that because it was going to go off the slide. So that's the WOSB program. Big changes there. Now let's talk about the limitation on subcontracting. This has been another one of those long-term things that has been in the works for a while. And by the way, I'll get to some of these questions hopefully by the end of the presentation. If not, I'll send some answers through the chat. Sorry. So every set-aside contract, i.e. every small business contract or WOSB, EDWOSB, SDVOSB contract must have a limit on the amount that the small business contractor may subcontract out. In 2013, through the NDAA, Congress changed the limitation on subcontracting, and that change was put into effect by the SBA through its regulations in June of 2016. The FAR has continued to lag behind. The FAR Council proposed changing the FAR last year. I do not believe that the FAR has changed as of yet, as of today. That could be coming along any time now. But effectively, most agencies, including the Department of Defense agencies, have adopted those changes through deviations, class deviations to the FAR. So those changes, for the most part, are in effect. However, we do continue to see in contracts the FAR clause limitation on subcontracting. So it's something to keep an eye out. You're probably asking what the difference is. Well, the FAR says that the prime must perform at least 50% of the cost of the contract incurred for personnel. So that's for service contracts. It's measured based on what you pay your people, right? So supply contracts, the prime must perform at least 50% of the cost of manufacturing, not including materials. The SBA rule, and I know it says 2013 NDA, SBA, DOD, let's just call it the SBA rule. The SBA rule says for service contracts, no more than 50% of the amount paid by the government can be paid to entities that are not similarly situated. So what that means is you get a check from the government for $100 and you turn around and write a $50 check to a subcontractor for doing its roofing work. You have just subcontracted out 50% of that contract. For supply contracts, obviously you see it there, it's 50% of the amount paid by the government that are to entities that are not similarly situated. We will talk about the limitation of subcontracting for construction, yes. So for general construction, the FAR clause said the prime must perform at least 15% of the cost of the contract, excluding the cost of materials. Specialty trade is 25%. The SBA reverses that. It's basically the same limitation, but it just says you can't pay out more than 85% of the amount paid by the government to firms that are not similarly situated, excluding the costs of materials. We will talk about similarly situated soon, by the way. Same thing with specialty contractors. You can't pay more than 75% to firms that are not similarly situated. Again, cost of materials excluded. What is a similarly situated entity? Well, it is an entity that has the same socioeconomic status as the prime contractor. So if the prime contract is a hub zone contract, for example, and then one of the subcontractors is a hub zone entity, then that entity is considered similarly situated, and the monies paid to that entity are not considered subcontracted money. Or moreover, compliance with the limitation on subcontracting is allowed through paying that subcontractor. So the idea behind this, by the way, is to say, hey, we set this aside for hub zone entities. We want those dollars to go to, at least a certain percentage of those dollars to go to hub zone entities. So if you're the prime in your hub zone and you pay money to another hub zone, well, it's still staying within the family of entities that are sought to be the beneficiary of this contract. However, if you turn around and subcontract to an SDV OSB, that would be subcontracted, even though it's a small business, because it's not the type of entity that the government is seeking to have the benefit of the contract. So, by the way, a very strange wrinkle in all this is that the similarly situated entity is determined by whether the entity is a small business via the NAICS code, the North American Industry Classification System code, assigned by the prime contractor to the subcontractor. In our experience, a lot of primes do not go through the effort to assign a NAICS code to the subcontract. But if compliance with the limitation on subcontracting is going to be, if you're going to stay in compliance by subcontracting to similarly situated entities, you can't forget to do that. Otherwise, it won't count as a similarly situated entity. One interesting thing that I don't think we know the answer to is, okay, what if the NAICS code is a 16 million size standard, and then you assign a NAICS code to the subcontract that's a 32 million size standard? It's bigger. Does that still become a similarly situated entity? I think based on the wording of the regulation, it would. But I don't think that it may not still be in the spirit of the law. Another quick rule change to limitation on subcontracting, late 2019. Contracting officers gain the discretion to request information about compliance, i.e. a contracting officer can say, hey, you have to tell me how you are going to be in compliance with the limitation on subcontracting. They also have the discretion to require compliance at the order level. So generally speaking, compliance would be measured based on the total contract. But if the contracting officer wants to, contracting officer can say, you have to comply with the limitation on subcontracting for this task order as well. It also excludes certain costs from the calculation, such as airline travel, cloud computing, mass media purchases, all that. More about the late 2019 change. There's an argument in size protests called ostensible subcontractor affiliation. So you can make an argument that a prime is too reliant or so reliant on its subcontractor to do the work that the subcontractor is a subcontractor in name only. So this change allows an entity, a protester, to assert that the prime contractor is reliant on a similarly situated subcontractor. No, I'm sorry, not similarly situated subcontractor, i.e. An SDVOSB. But if they are similarly situated, then no ostensible subcontractor affiliation can be found because, like we talked about before, the idea is for the benefit of this contract to stay with the type of entity that the contract is set aside for. Some big updates to the FAR. This came out, not long ago. NAICS codes must be assigned to every solicitation, contract, and order, including delivery orders. So the NAICS code must be listed on the underlying contract for a delivery order. And if you have a multiple award contract, the contracting officers can now select more than one NAICS code to assign to a multiple award contract, i.e. there's not one that best describes the purpose of the contract, so we can assign several. By the way, if you are representing your size on a multiple award contract and it does have many NAICS codes assigned to it, you have to represent your size for each code. Currently, contractors had to, not currently, but previously contractors only had to recertify their size in the event of a novation or a merger or a long-term contract like we talked about, over 5 years long. Now contractors must recertify their size and their socioeconomic status in certain circumstances, including when the contracting officer asks a contractor to recertify and in the event of a merger or acquisition. If after such a request, the contractor is no longer eligible from a size or socioeconomic status standpoint, that doesn't mean that the contractor loses the contract. It means that the agency can no longer count those contracting dollars toward its goaling. Would that prohibit an agency from issuing new task orders, for example? We don't know the answer to that. This is the last and probably the most welcome of the changes we saw over the last 15 or so months. No more Fed Biz Ops. Now the government has switched all contract seeking opportunities to beta SAM, and it has now become the hub for all these previous portals, including FBO, FPDS /NG, wage determinations, and of course SAM registration. While it has been a bit of a bumpy transition, I think most people agree that Fed Biz Ops was not the most user-friendly platform. So hopefully this will ultimately be a very good change. So there has been some confusion as to when an entity must be registered in SAM. As of late 2018, and I just want to squeeze this in, offers must be registered at the time of the bid, and they must verify that their SAM registration is current, accurate, and complete. Remember, this is sort of a key. Companies are very good at ensuring their SAM profile is current, accurate, and complete. However, when they're in a joint venture, they're often not as good at updating their SAM profiles. So it's just something to keep an eye on if you're in joint ventures. You have to make sure your SAM profile, you're registered, and your SAM profile is current, accurate, and complete as of the time of bid. Future changes. There's quite a bit on the horizon, and we're not going to go into huge detail of all that, but you'll see what I mean. So there was a proposed rule to make some very big changes that has not passed as of yet. Most of them are likely to pass, in my opinion. One of the proposed changes is to consolidate the mentor protege program. So the SBA currently runs both the 8A mentor protege program and the all small mentor protege program. They have essentially the exact same rules, regulations, benefits. The only difference that I'm aware of is to be a protege in the 8A mentor protege program. You have to be an 8A contractor. That's literally the only difference. So this proposed rule change would consolidate those two programs, and there would simply be one SBA mentor protege program. It's a pretty good idea, and it's almost certain to happen. There is a part of that which might cap the size of mentor companies, but that's just something to keep an eye on. This change would also eliminate joint venture pre-approval requirements for the 8A program. The SBA it's probably quite a bit of a headache for the SBA, frankly, to approve all joint ventures that are seeking 8A contracts. One thing, since the entity that is in the 8A program has already gone through the approval process, if it forms a joint venture, it could be much easier and simpler for that bidder, the joint venture, to certify when it submits its bid that it is an eligible 8A joint venture. The joint venture pre-approval process would not go away for sole source awards, we are to understand. But that's another one where contractors often go into trouble, because not only is the joint venture required to be approved, if the joint venture seeks another 8A contract, it must submit its addendum to be approved for that second project. Speaking of joint ventures with multiple contracts, this proposed rule change would eliminate the 3-2 rule for joint ventures. What that rule is that a joint venture can perform no more than 3 contracts over a 2-year period without becoming generally affiliated. So this is not a cap on the amount of contracts a joint venture can do. It's an affiliation rule. So if a joint venture has hit 3 contracts over a 2-year period and it seeks a 4th, that's fine if the joint venture members understand that they're going to be affiliated if they get that 4th and perform that contract. This change would simply do away with the 3-2 rule and create a 2-year rule. So joint ventures will simply perform as many contracts as they can over a 2-year period. Again, in our opinion, this is a great change. It's a simplification. The 3-2 rule is something that is very confusing to contracting officers, but also it doesn't have a lot of teeth, because the rule can be easily circumvented by simply forming a new joint venture. And then finally, the proposed change would require recertification for orders set aside under unrestricted IDIQ contracts. So, i.e., you get an IDIQ contract, and then a task order comes out as a restricted task order. Contracting officers would require recertification in that circumstances. A few other things. DUNS numbers are going to go away by the end of the year. They're becoming unique entity identifier numbers. You will request a UEI in SAM, and if you are already in SAM and have a DUNS number, a UEI will be automatically generated for you. The number will be 12 characters. It will include letters and numbers. And your DUNS number will not go away. It will remain on your record for historical purposes, but the UEI will be what the government uses to identify you. Furthermore, GSA is looking at consolidating schedules. A solicitation was released in late 2019. It will migrate existing schedules into the consolidated existing contracts sometime this year. It may, in fact, be going on right now. I honestly am not certain. Another key change, Executive Order 1349-5, non-displacement of qualified workers. I'm sorry, I'm speeding up a little bit. We're running out of time. This was a right of first refusal for incumbent workers. It's kind of an executive order that comes on and off the books based on who's in the White House. This was revoked in 2019. The FAR has incorporated that change to remove references to non-displacement of qualified workers, but you should still verify that when you're going through your contracts to bid on, to see if you still have to offer a right of first refusal to qualified incumbent workers. And sort of last but not least at all is the government's focus on cybersecurity. Big steps to change your cybersecurity requirements. I am not gonna go through all this, but just be aware that there are FAR clauses that require cybersecurity. Those clauses are going to flow down to subcontractors. And this, of course, is the big one here, the cybersecurity maturity model certification. The government has taken great pains to require Department of Defense contractors to comply with a cybersecurity model. Cybersecurity certification will be given a level. The level will be assigned from 1 to 5. There will be contracts that will say you have to have a certain CMMC level in order to bid on this work. There will be third parties who will perform audits to determine what level you should be at. The government said that it would start incorporating those standards into solicitations in summer. It has since revised that approach to probably fall, although the question came up to us, is this something that's going to be required beyond the Department of Defense? We didn't know. Now we do know, yes, it is very likely to be required beyond the Department of Defense. In fact, if you look at the GSA STARS 3 solicitation that just came out, it does mention CMMC requirements may be part of requirement for STARS 3. We do have a little bit of time, so I'm going to try to get to the questions. I stopped my screen share. Where do we have the chat? All right. So question 1 from Angie Cash. If a firm is an 8A, EDWSB, or CVE, do they still need to complete the SBA application for EDWSB and upload documents? I think what you're asking is if you're 8A and you're CVE, are you automatically certified as EDWSB? No, I don't believe so. You would have to upload an application, put in an application and say, basically your application is going to consist of proving that you're already 8A certified. So you should automatically be EDWSB. certified as well. What is the best order? Debbie asks, what is the best order to get certified in between HubZone, WOSB, ED, WOSB, and 8A? I don't have an exact opinion on that. It's whatever's best for your business. I can say the 8A program is kind of the gold standard program because the 8A program focuses most on sole source awards, and it is a business development program, so there are some other advantages associated with that. If you're going to be 8A eligible, I would say you should seek to be 8A certified, yes. The other programs are excellent programs. The 8A program is the gold standard. We talked about limitation on subcontracting for construction. I'm happy to speak more on it if anyone would like. I see there's a question here from Tom that says, I'm a manufacturer rep of manufacturers GSA certified. How do I fit into the bidding and purchasing process? Tom, I gotta say, I don't know. But if you want, you can email me. I'm gonna share my screen again, show my, my contact page, and you can email me. By the way, we sell handbooks. They're available on Amazon. If you're looking to educate yourself, please go ahead and take a look at those. There's my contact information. If you have a question for me, please email me. I've included my personal email account. If for any reason you can't reach me at my work account. And I think I have gone a little bit over time. So I guess I better turn it back over to Bourbon.
All right, thank you, Matt.
Do you all have any questions?
You didn't go over that much.
That's the first.
It's all right. All right. Well, actually, it's Carter. Or do you want me to do it, Carter?
We're ready for the next session. Matt, I really appreciate you doing this. As always, it's been very helpful to get your update on all the changes. And I think I agree with you. This is an amazing year for changes. The amount of changes and the number of programs affected.
You'll notice I barely mentioned COVID-19.
Yeah, not to mention the whole global pandemic thing. So it is a wild year.